Hi, hello everybody. Thank you for attending our webinar today. Before we started, we wanted to cover a couple of housekeeping issues. If you have any questions during the webcast, you can submit them through the Q&A widget that you should see on the bottom of your screen. We'll try to answer them during the webcast, but if a more complete answer is needed or if we run out of time, it will be answered later in an email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. And you can find additional answers to some common technical issues located in the help widget at the bottom of your screen. If you have any technical problems during the webinar, those can also be reported through the Q&A widget. For CLA credits, this program is approved for 1 hour of discrimination and inclusion credit in California, 1 hour of diversity and inclusion credit in Illinois, 1.2 hours of elimination of bias credit in Missouri, 1 hour of diversity, inclusion, and elimination of bias credit in New York for experienced and transitional attorneys, and 1 hour of ethics credit in Texas. We award CLE based on attendance for the entire 60 minutes. And to demonstrate your continued engagement, we will display secret words in 2 multiple choice polls during the presentation. You'll be required to select today's secret words from a multiple choice list. Please do respond to those polls in order to earn your full CLE credit. We value your opinions and appreciate your participation in the course. After the presentation, we'd appreciate it if you would also complete and submit the survey that we'll display at the end of the session. That said, good morning, everybody, or good afternoon now, depending on where you are. My name is Allyn Lowell. I'm an attorney in our Texas office, Dallas, Texas. I'm a labor and employment attorney of 19 years, been board certified in it for 10. And I have with me, who will also be presenting, is Stephanie Fredman, who is a labor and employment litigator in our St. Louis office, and she assists with matters involving discrimination law, student affairs, and policy development. So we've got both of our contacts information there if you need either of us at any point after the presentation. So, previous slide, it sort of shows what we're going to go through. This is what we're talking about today is good policies and when they create risks. Specifically, we're talking about policies that have to do with Title VII, workplace discrimination, how that's now being enforced by the EEOC and other agencies. And then to sum it all up, we'll be talking about diversity considerations, including different DEI or similar kinds of policies or programs different employers might have concerns about these days. So let's start it off with a view, just an overview of Title VII. I'm sure that most people on this webinar are fairly well acquainted with Title VII, but it's worth it just to go over the background so that we have the framework of what's changing and what we're sort of talking about going forward. So Title VII, as I'm sure everyone knows, it prohibits discrimination in employment on the basis of these specific characteristics: race, color, religion, sex, and that includes pregnancy and an addendum in the Pregnancy Discrimination Act, and national origin. And so it prohibits that discrimination by taking any sort of adverse action against an employee, which could be refusing to hire them, termination, demotion, any other kind of action that results in a change in the individual's compensation terms, conditions, or privileges of employment. So that could be moving to a lateral but less desirable position, different location that's less desirable, taking away functions of a job like sales that would have normally resulted in commissions. Those kinds of actions are all contemplated by Title VII. And that sort of sums up what I just said, but it applies only to employers with 15 or more employees, and Title VII is enforced by the Equal Employment Opportunity Commission, or the EEOC, and the Department of Justice, although in different cases. So the EEOC largely handles Title VII as to private employers, private employees, litigants pursuing their discrimination claims, whereas the DOJ, through its Civil Rights Division, enforces Title VII as to pattern or practice lawsuits against state or local governments. So it's focused more on larger scale compliance with Title VII. now I'll turn it over to Stephanie.
Thanks, Allyn. Title VII also indicates that state law matters. It's important to know what the laws are in your state to determine if there are greater protections than what Title VII covers and what Allyn just went over. Many states have human rights laws that actually do provide for additional protected categories or other ways that the state law actually calls for greater protection. So this can be, as I said, additional protected categories. It also could be that the law kicks in with fewer employees than that 15 number that Allyn just mentioned. Additionally, some state laws actually provide for individual liability as well for similar types of claims of discrimination. And understanding what the laws are in your state or the state where you have employees is important just to ensure compliance there. So there's nothing in Title VII that indicates that state law shouldn't be taken into account and shouldn't be addressed. So we're going to talk throughout this presentation about the EEOC, and as Allyn said at the beginning, we're going to talk about just some enforcement trends and kind of how things are playing out at the EEOC, currently. But I wanted to just provide a little bit of context to the background there. And many of you, or most of you, are likely familiar with this process. But just to provide, what happens once a claim or an employee comes forward saying that they've been discriminated against, what happens there? So in order to bring a claim of discrimination under Title VII, a complainant has to first file a charge with the EEOC. So a charge has to be filed first before somebody can initiate a Title VII complaint in court. There's a 180-day calendar day filing deadline, although in many cases this is extended to 300 days. That 300-day deadline comes into play if there's a state law prohibiting age discrimination in employment and a state agency or authority enforces the law. So, many times, we see that this to be the case, that there's that 300-day deadline. However, if you're in a state where those two things aren't at play, then that deadline is 180 days. As many of you know, there's an investigation process that occurs with the EEOC, and that process includes often submitting a position statement, providing supporting documentation. Sometimes you can get a request for information even after a position statement is submitted that asks for specific types of information or maybe even interviews from individuals, and ensuring that you're providing as much information as you can to assist with that investigation process is something that can be helpful at this stage. After the investigation process occurs, the EEOC will make a determination of whether there is reasonable cause. If they are unable to determine there's reasonable cause, then a dismissal and a right to sue letter will be issued. If there is reasonable cause that's determined by the EEOC, then a letter of determination and conciliation will occur as the next step. So basically, the EEOC will try to resolve the charge through a more informal process called conciliation if cause is determined by the EEOC. Following that, if conciliation, if it can't be resolved, then the EEOC can actually initiate a lawsuit on behalf of the employee. And as we'll talk about later on in the presentation, that's in a very, very rare situation that occurs. So that really is just the basics of what happens in the EEOC process. There's certainly other ways that an employee can get a right to sue letter. They can request one, and there may be some changes to that we see moving forward too, just based on timing and just what types of claims are coming through. All right, so moving our discussion to workplace discrimination, we wanted to talk first about protected categories. So as Allyn and I both talked about earlier, Title VII protects against discrimination on the basis of race, color, religion, sex, and national origin. There have been some recent cases and case law that have talked about these protected categories and have helped provide some guidance for what Title VII actually does protect and what it covers. So the first case I wanted to talk about, which is actually now not a totally recent case. It's crazy that this is a 2020 case and 5 years ago now, but is Bostock versus Clayton County. Here, the plaintiff had identified as a gay man. And once his company found out that he had identified as a gay man, he started to receive some negative performance reviews, and some comments were directed towards him based on his sexual orientation. He was ultimately fired from his position as well. Following his termination, he brought a lawsuit that claimed that he was being discriminated against under Title VII based on his sexual orientation. The lower courts in this case all held that Title VII didn't cover sexual orientation, and they relied on an older case in order to come to that conclusion. However, when the case got to the Supreme Court again looked at this question of, does Title VII of the Civil Rights Act, which prohibits against employment discrimination because of sex, encompass discrimination based on an individual's sexual orientation? And ultimately, the court found that yes, it's unlawful to terminate an employee take any adverse employment action against an employee merely for being gay or transgender under Title VII. The court looked specifically at the language of Title VII in order to come to that determination. We raised this here to provide this context of what a protected category is and what's covered under Title VII. This is, still the good law and the law that's in place, but we will talk some about some recent changes that have drawn this into question, and where just new guidance and new information has come out recently on this that just pose different questions and have you thinking differently about what Title VII covers and what might be considered moving forward. So the next case that I want to mention is Ames versus Ohio Department of Youth Services. This is a recent case from this year. Ames addressed the question of whether or not a plaintiff who belongs to a majority group needs to demonstrate background circumstances suggesting that the defendant is the unusual employer who discriminates against the majority in order to establish a prima facie case of discrimination under Title VII. So here the Supreme Court was addressing a circuit split that existed where some circuit courts and courts of appeal had indicated that there was a higher standard for those in the majority group when it came to Title VII cases. And the Supreme Court, in looking at this, held that employers violate Title VII when they intentionally discriminate against any individual. So there is not this higher standard for those in a majority group. And that language and that holding, we've already started to see come up in other cases that address additional issues such as hostile work environment and training and some other things that we're going to get into throughout the course of this presentation. So ultimately, no higher standard for those in the majority group. And I will hand it back over to Allyn to talk about types of Title VII claims.
All right, thank you. So we talked earlier just about disparate treatment claims, right? Where there's one employee and they feel like they've been aggrieved because of a demotion or termination or what have you. And so they file a charge alleging that adverse employment action was caused by or was motivated by their inclusion in a protected class because of their race, their color, their sex, religion, etc. There's also a separate kind of claim, disparate impact claim, and that's where there's a policy or practice that has a discriminatory effect, and that's where the policy is actually itself facially neutral, which is to say that it appears to be fair and non-discriminatory, but it nonetheless has a disproportionately negative impact on a group that shares a protected characteristic. So in those sorts of cases, the burden then comes to the employer after the employees are able to demonstrate this disproportionate negative effect. Then the burden shifts to the employer to justify the employment practice that's causing that impact by showing that the practice is consistent with a business necessity. So you can think about it in terms of if a strength test impacts women in a negative manner because they're not as able to lift as much or do as much strength-wise as a man. Well, there are certain jobs where strength may be the requirement. They're firefighters. In an accountant's office, it's less it's less easy to see how that would be a justifiable practice to have, right? So those are the kinds of cases we're talking about here. And you may have heard that there was this executive order 14281 that was put out by the Trump administration earlier this year called Restoring Equality of Opportunity and Meritocracy. And that's really the administration's policy is to, in their language, eliminate the use of disparate impact liability in all contexts to the maximum degree possible to avoid violating the Constitution, federal civil rights laws, and basic American ideals, end quote. So this EO is primarily addressing Title VI of the Civil Rights Act, which prohibits discrimination in federally assisted programs, but it does also direct agencies, including the EEOC, to deprioritize enforcement of statutes and regulations that impose disparate impact liability. So the EO does not actually alter, rescind, add new existing law or regulation for private employers. The disparate impact claims have been recognized under Title VII since the Griggs versus Duke Power case came out of SCOTUS and the Supreme Court in 1971, and it was thereafter codified by Congress in the Civil Rights Act of 1991. So it's still a good law, but this is just sort of a forecasting of what the administration and thus what it's directing agencies to do. And in this case, it is to deprioritize looking at those kinds of claims that allege a facially neutral policy or practice that has a disproportionately negative impact on one group or another. A couple of other kinds of Title VII claims. We've all heard about hostile work environment. That's a claim where the employee says that their workplace is so permeated with severe, pervasive conduct that's unwelcome, it's discriminatory in nature, it creates an intimidating, offensive, abusive atmosphere that really interferes with the employee's ability to even do their job. So that kind of a claim is to sustain such a claim, the employee has to show both that they subjectively find the conduct offensive and also show that the conduct in the workplace is objectively offensive to fact-finders. Retaliation is another kind of standalone claim here. That's not going to come up as much here. That's not really implicated in some of the changing guidance that we're talking about today, but just to note it again that it is a standalone claim, and it's one where the individual alleges that they complained in good faith, maybe internally to the company, or they participated in some sort of internal or external formal practice, like going through the EEOC, assisting with filing a charge or testifying on another employee's behalf. Any of those kinds of good faith actions where the underlying conduct that's being complained about is itself illegal discrimination in employment. That's a separate cause of action. And we now have today's first secret word. It is compliance. Please select that from the options you see below and give about a minute for that to happen. So again, the secret word now for CLE credit is compliance. You can select that. We see those numbers are still climbing, so I just want to give another little bit to get that answer in. If you're looking for the CLE credit for today, the answer is compliance. I still see some trickling in, so I'm trying to give everybody time. We're getting close here. All right, I think we're probably close to having everybody vote. Stephanie, if you want to.
Sure. Yeah.
Pick it up.
All right. All right. So talking about regulatory enforcement. Looking at a few enforcement trends from January to July, there were 9 actions that have been initiated by the EEOC. And as I mentioned earlier, that is one route that the EEOC can take when they do find a cause determination and conciliation is unsuccessful, is that the EEOC can initiate lawsuits on behalf of an employee. These 9 lawsuits are interesting because I misspoke a little bit there. This 9 actually includes both new lawsuits, so the new actions that the EEOC would take, and then also appeals as well. So cases that may have already been pending before the Trump administration came in January. And this is actually a pretty low number compared to the same point in the Trump administration's first term. And these cases involve all different kinds of protected categories. So based on that, it's pretty difficult to draw any type of conclusions as to whether or not the EEOC is looking at certain types of cases that they're going to initiate on behalf of an employee. And I do just want to give a shout out to our colleagues who put together a summary of this information in enforcement trends too. And, many of the statistics you'll see today come from that information. So there have been reports that indicate the EEOC is going to focus on anti-Semitism on college campuses throughout this administration. And recent large settlements have shown this priority with universities. This has clearly been something that's been in the news, and it's anticipated that enforcement and focus will continue. Since January, the EEOC has dropped at least 22 cases. The majority of those involve disability discrimination cases and gender discrimination cases involving transgender or non-binary workers. Looking specifically at February, the EEOC filed motions and other stipulations to dismiss 7 gender discrimination cases that did involve transgender and non-binary workers. The EEOC noted in these filings that there was a potential inconsistency that might arise between new executive orders and what the lawsuits had been initially filed under. So indicating that there was a claim of discrimination based on sex, and that interpretation of sex seemed to be at a bit of a disagreement with what recent executive orders have stated. So looking specifically at Executive Order 14168, defending women from gender ideology extremism and restoring biological truth to the federal government, the executive order looked specifically at this Bostock case that we had talked about earlier, and indicated that really there might be a move away from that. So in looking at this language here, this is looking at something very specific in terms of Title IX and education on college campuses. But I think that there's something here just in how the administration is interpreting and looking at how the definition of sex is understood and identified through different laws that define these terms. Title IX is one of them, and Title VII is another, clearly. The executive order also states that sex is not a synonym for and does not include the concept of gender identity. So that alone is sort of putting these issues at odds of, how can the EEOC bring a case on behalf of an employee that is based on sexual orientation and gender identity when this recent executive order is saying that they're not the same. So that's what the EEOC was filing motions on, and had these cases dismissed over sort of that inconsistency that existed. However, just recently in July, the EEOC began to process some claims on the administrative level that do involve transgender complainants. So we are not seeing a total rollback on that, and it does seem as though that the EEOC is processing them and investigating them on some level, and that was, again, just recently in July.
Sorry. Back in March of this year, the EEOC issued technical guidance, and there's two pieces here. Both the what to do if you experience discrimination related to DEI at work, and then there was a Q&A technical assistance document that went along with that, was what you should know about DEI related discrimination at work. So this is just advisory to potential would-be discrimination claimants, and some question and answers about what the EEOC sees as being discrimination related to DEI, because I think we all would like to know. The guidance begins by acknowledging that DEI is in fact not defined in Title VII. It's a broad term, and I think across different industries, across different companies within industries, it could be used differently to know different kinds of things. The EEOC also reiterates in this guidance what we already know, which is that Title VII protects all workers from discrimination on those protected bases, not just individuals in a minority group. So it's reaffirming the idea that there's not such thing as a reverse discrimination. That said, if a program, initiative, policy, practice that's created in the name of DEI or with an express goal of creating a diverse workforce, if such program, policy, initiative, et cetera, if that results in actionable discrimination, such as where certain individuals are not hired because they are not members of a protected group, the EEOC does say that that would constitute illegal discrimination as being related to DEI, and as excluding some people from a fair and equal workplace. The EEOC says that there's no justification to make those decisions that are motivated by protected characteristics, even if it's because the employer has an interest in advancing diversity, equity, inclusion, even if there's a business interest, such as it's, the employer's clients and customers want this. The EEOC says in this guidance that that's not justification to continue on with any of those kinds of programs that result in that what they see as actionable discrimination. So some examples of what they talk about, that what the EEOC talks about that might constitute unlawful DEI-related discrimination. There's things as limiting participation in workplace groups like affinity groups to individuals that have a certain protected characteristic. So you can have workplace groups, but they need to be open to everyone to join and not closed off from some. Similarly, providing meeting space for some employee-led clubs and not others. So if the favored clubs were related to diversity, equity, inclusion, or if they expressly were for a certain group that has a similar protected characteristic, the employer can't favor that group over others. So the workaround isn't that the employer needs to end all of those kinds of groups or programs. It's just to make sure that they're all being treated equally in terms of being allowed meeting places within the facility, being given whatever time they may have to participate in those. That's all administered and fairly. Similarly, the EEOC notes that segregating employees into different groups in order to train them on DEI or anything else could be discriminatory. And they also go so far as to say that conducting DEI training, even though we don't really know what the definition of that is, but that could be discriminatory. That's going to be highly fact specific in terms of what the training covers and just really the context of what's happening there, what kind of policies are being implemented, et cetera. Only providing access for certain employees to be able to pursue internal leadership development programs, or I could see that being extended to only nominating certain employees for external leadership programs, and those nominations or those inclusions being based on a protected characteristic. That would be DEI-related discrimination pursuant to this guidance. And for the last one there as well, to select a diverse candidate slate, if that happens because it's merit-based, there's not an issue there. If the candidate slates or the hiring pools are pulled together with the idea of making them diverse at the outset, that would be where the EEOC sees an issue. There have further been some changes that have occurred because of judicial intervention. So the EEOC guidance that was issued in 2024 was the first time it had been updated since, I believe, 1999. So there was a lot that needed to be incorporated there. But just because the scope of Title VII or how it's interpreted had changed a lot during that time span. So key differences were to expand the protections available for LGBTQ workers, for pregnant workers, to discuss things like virtual workplaces and how harassment could still happen even in a virtual workplace, and to go over some other sort of systemic and color-based harassment. In 2025 of this year, the Northern District of Texas, the judge there decided that, or found that the EEOC had exceeded its authority in expanding sex in that guidance to go beyond just a biological male-female binary. And so because the court found that the EEOC didn't have that statutory authority to expand that definition, it vacated the portions of the 2024 guidance that related to specifically to gender identity and to the definition of sex. Thereafter, the EEOC did issue new guidance, and it recognized that finding and incorporated it into that guidance. The EEOC had not been able to do that prior, just because there's not a quorum within the commission right now, and so they can't change other guidance without having that quorum. And below at the last question here is something that Stephanie, I think, has already touched on, and so I won't belabor that. But this, again, goes back to the idea of what Bostock held in terms of allowing for Title VII to reach sexual orientation discrimination in the workplace. So this is just guidance that's changed here. Vacating a portion of EEOC guidance doesn't do anything to, to negate, to undo a Supreme Court holding like Bostock. But we are talking about both these things together just because of the understandable confusion that comes from having different authorities really saying kind of different things about this specific topic. So in light of the new EEOC guidance, I've been asked occasionally whether or not that means that employers should change their policies, if there's something in any of the new guidance, or the fact that the guidance has been in part vacated and reissued, if what practical effect does that have for employers? And so the way that I would want to look at it is just as I think Stephanie talked about earlier, about how there can be more protections given, say, by a municipality or by a state beyond what the federal government does. So from my mind, since I'm in Texas and we have very few additional regulations and laws in the employment law realm, but compared to California, which has a lot, right? So and those are just states' rights issues. So they can give more protections to their employees beyond what the federal government already provides for. And private employers can similarly, attempt to give more protection to their employees than is actually required. Now, what becomes problematic is where, by implementing that attempt to protect people into policy, and if that policy then is at odds with what the federal government is saying, or when they say that some policies themselves, even in attempting to be, or with perhaps the stated goal of protecting more employees, when that actually ends up becoming discriminatory against other employees in the workplace. So for many private employers, that could mean that if their policies already encompass very specific things about rights for non-binary trans people in the workplace, that's just saying that you can't we're not going to discriminate against these people, that's going to be fine. Where we start seeing some issues is where there might be policies about the right to use this bathroom versus that bathroom, and if there are others in the workplace who feel somehow offended by by offering different kinds of facilities to different groups, that's where we just see a need to be cautious about really putting everything into policy. I mean, allowing additional facilities without directing employees to one or the other is going to be a safer option than actually spelling it out in a policy that this is where these people use the restroom and that's where these people use the restroom. So insofar as people think they need to include any of the magic language of the EEOC guidance into their policies, it's likely unnecessary, assuming that employers already have standard EEO policies about we don't discriminate, or we don't discriminate against people for these protected categories. We don't retaliate against people who bring good faith complaints, that sort of thing. There's no need to incorporate specifically in any of the new guidance. It's more, we raise it more just to be aware of it because it forecasts and signals what the EEOC is interested in pursuing in terms of the claims that they, that could come across their desk, and what they're more likely to look at with interest, and what they're more likely to maybe move by. Although, as Stephanie just mentioned, that some of those trends are still up in the air a little bit. And next, I thought I would just go through some of the executive orders that people have probably heard about, just to kind of talk about what they're about, whether or not there's something to be concerned about if you are a private employer. Now, there have been a lot of EOs that actually speak more to federal contractors, and because that's a pretty complex, detailed whole area that is, not really applicable to everybody, we're not going to get really into the details of that. But I would just mention that we do have federal contracting attorneys here at the firm who are great resources for any of those kinds of questions. Should anyone in the webinar have those, we'll be happy to direct you to our specialists in that area, if that's needed. All right, so 14-148, that's the executive order titled Initial Rescissions of Harmful Orders and Actions. That was just revoking numerous policies that have been enacted under the Biden administration, and those had been designed to advance racial equity, to promote diversity, equity, and inclusion across federal agencies. And so in rescinding these policies, the Trump administration is just signaling its shift away from those initiatives. This isn't particularly relevant to private employers, other than just understanding the overall landscape while this administration is in power. 14-151, ending radical and wasteful government DEI programs and preferencing. This is really significant for its termination provision, that the executive is ordering every agency, department, commission to terminate any equity-related grants or contracts. So if there are those kinds of equity-related grants or contracts that are they're actually issued by a federal agency, the administration is trying to end those. Stephanie already spoke a little bit about Executive Order 14168, defending women from gender ideology extremism and restoring biological truth to the federal government. That is again the stated purpose is to protect men and women as biologically distinct sexes. So their goals there are, these are quotes, remove all statements, policies, regulations, forms, communications, or other internal or external messages that promote or otherwise inculcate gender ideology, and shall cease issuing such statements, policies, regulations, forms, communications, or other messages. So basically they're trying to end any federal funding of gender ideology or programs or communications that have to do with gender ideology, and not to use federal funds in that whole arena. The EEOC, after this EO was promulgated, the EEOC issued a press release, and it announced its own commitment to protecting women in the workplace. And subsequent to that, it removed some gender markers from form charges of discrimination, and has removed some internal and external materials that promoted gender ideology. So this EO doesn't directly impact private sector employers or employees, but there are sort of trickle-down effects here. So that's why we include that. EO 14173, ending illegal discrimination and restoring merit-based opportunity. So this was creating new obligations for organizations that do business with the U.S. Federal government, like federal contractors, subcontractors, recipients of federal grant money, and it subjects those entities to possible civil and criminal penalties under the False Claims Act for failing to comply with certain certification requirements. So that EO requires those different types of organizations to certify that they don't operate programs that promote DEI in a way that violates anti-discrimination laws, which is sort of a circular thing where we have to go back again and try to figure out what DEI violates federal anti-discrimination laws. But again, luckily this is largely only specific to organizations that are federal contractors or subcontractors that receive federal grant money. So this is not, I think it's something for private employers to be aware of, but it's not something that they need to be immediately worried about trying to, to comply with, or to have their own model comport with. So, let's see. Okay, and then the last two, I think these last two EOs more or less speak for themselves. Additional measures to combat anti-Semitism. That's primarily interested in political or protest activity at schools and universities following the October 2023 Hamas attack. Both the DOJ and the DOE, the Department of Education, opened investigations into some universities as a result of that. And then the eradicating anti-Christian bias. Again, this is just establishing task forces within the federal government to look at conduct or actions that the administration or the task forces believe target peaceful Christians. Okay, so again, these EOs that just discussing, a lot of them aren't directly impacting employers, private employers, but they are good forecasts of what the enforcement priorities may be. Charges with claims of anti-Semitism, of discrimination, perhaps by minority groups against majority groups, religious discrimination, all those kinds of things we would not be surprised to see an uptick in. But that said, the EEOC's enforcement priorities have never affected the underlying substantive rights of claimants to file a charge, which of course they have to do to exhaust their administrative remedies, and then to request a notice of right to sue and to bring a suit in court. So just because the EEOC is not particularly interested in one area of Title VII protections doesn't mean that that affects litigants or claimants' rights to pursue those claims, both in the EEOC and then in state and federal courts. So we may not see as many cause findings drawn for the groups that the EEOC is not as interested in right now, but again, employers shouldn't let their guard down as to all of the different protected classifications, because they all remain protected under law, regardless of what the EEOC prioritizes as enforcement. I'll hand this back to Stephanie.
Thanks, Allyn. So in going off of that and talking a little bit more about policies and then getting into training as well, as we've discussed throughout this, policies need to be neutral. They can't benefit one protected class over another. So, we have seen some examples of policies that would have financially benefited a certain group of individuals in order, the purpose behind it was in order to, promote or support or, really wanting to provide additional guidance to a certain group of employees. However, we've seen that the Department of Labor and others have taken a stance on that, indicating that policies that are going to benefit financially or in other ways that are, again, benefiting one group over another, those are the ones that are certainly going to pose additional risks to companies. So taking a survey of your policies, seeing if anything like that exists, especially ones that do provide sort of that financial benefit in one way or another. Then looking at training, we know that this has been an issue that's been on the minds of many, especially in light of the recent DOJ and EEOC guidance. And I actually want to start talking about training with this case from 2024, honeyfund.com Inc. versus Governor. So this is a Florida case, and candidly, this is not a Title VII case, but it does touch on some interesting issues that affect everything that we've been talking about throughout the presentation today. So here, the state of Florida sought to limit topics that employers could mandate that their employees have meetings on. So basically, the state of Florida had provided a list under the Stop Woke Act of what types of meetings would be prohibited for employers to require for employees. This list was really based on issues relating to sex, race, and national origin. And when the 11th Circuit looked at this case, and they actually addressed it from a First Amendment perspective, and again, not a Title VII perspective, but when they looked at this case, they indicated that while there was a list of meetings that the state of Florida was seeking to limit, there were some topics that had to do with sex, race, national origin, religion, that the state of Florida did allow. And in doing that, in saying there's some topics that can't be covered, but some topics within those same categories that could be covered, it was limiting speech in an impermissible way. And one of the arguments that you see in the case is that the state of Florida indicated that some of the topics that they were trying to limit would create sort of this hostile work environment, and they would, basically create an environment that was not welcoming and not, supportive of everyone within the workplace. And the court really didn't address that piece of it, didn't address the hostile work environment piece, and really looked only at the First Amendment language. But it is just sort of an interesting primer for where things have gone, and additional discussion on these topics of training. As Allyn mentioned earlier, so the technical assistance documents have indicated that an employer's DEI trainings could create a hostile work environment, depending on what those trainings look like. And there are some recent cases that have looked at this and have discussed that. And there are at least 3 cases pending in the Court of Appeals right now that are relying in part on Ames versus Ohio Department of Youth Services, which we talked about earlier, that are looking at these ideas of hostile work environment in terms of training. They're challenging lower courts' decisions that trainings that specifically discuss race, so whether they're talking about implicit bias or other types of topics that are looking specifically at one race or another, or history of race or things along those lines. Those courts, in the case that I have here on the screen, indicated that alone, having a training alone that talks about these topics doesn't necessarily mean that there is a hostile work environment. And in DeMert, for instance, the court found in that case that there was no hostile work environment based on those trainings that were being provided. And there's a number of other examples that have held similarly, that just having a training on implicit bias alone does not create a hostile work environment. What's interesting about it, though, is that many of these cases, the decisions came down before the EEOC and DOJ guidance came out in March. And there are certainly other examples since that guidance came out where courts are holding in employers' favor that trainings are not creating a hostile work environment. But it certainly is something that is being litigated currently right now. And I think that keeping an eye on what happens with these types of trainings and what the courts say moving forward is something that is going to be needed. As of now, I think this is still sort of a to be determined, to see what happens in terms of what the courts are going to do, and whether they're going to align more with what we've seen in that guidance, or if we're going to continue to see what we've seen previously, which is more of a looking at the totality of the circumstances, how these hostile work environment claims are often analyzed by courts, and not just looking at, does one specific thing create a severe or pervasive environment? But I'm really interested to kind of see what happens with the cases moving forward, and I'll certainly be keeping an eye on these appeals. This DeMerck case, the DOJ actually is backing the appeal for that one as well, and it does sort of show that reliance on that guidance, that there may be issues of law there in terms of what is creating a hostile work environment. It's interesting that they are relying in part on the Ames holding that was earlier this year, because as we talked about, the Ames holding is really looking at whether or not there's that higher standard. And these hostile work environment claims are really not being analyzed based on that, of if there's a different standard or a higher standard for those in a majority group. So that too will be interesting to see how and whether or not that does get applied to these types of claims. Another recent case that talked about implicit bias is this California case here. As I mentioned, there are some specific examples of where the courts have allowed for and upheld trainings that include some of these topics and some of these issues, and just having a training alone on these types of things is not necessarily unlawful or create a hostile work environment. So just talking about a few trends that we've been seeing. So, I think this goes true across many different industries, and likely is affecting many companies in different ways. But the messaging around DEI, we're seeing that being adjusted, and how companies are talking about diversity issues and how they're presenting that to the public is something that has changed. There's been some changes in disclosures by public companies, in required disclosures that need to be made. We are seeing, though, that the trends are more that companies are still disclosing the demographic makeup of their companies, though. And while there might be a shift in that language that's being used, there is still, seems to be at least, some need to provide transparency from companies on what their workforce looks like. All right, and we're at the second secret word. Today's second secret word is enforcement. Please select the correct answer from the options below. Again, the second secret word is enforcement. And as you're doing that, I know we're coming up on the hour here. If you have any questions, please feel free to enter them into the chat.
And there was one question that I just wanted to quickly answer because it's easy, which is to say, does Bostock also extend to gender identity? And it did, yes.
And just one other note too, about going back to policies that affect or benefit one protected category over another. I know that on the higher education context, I think there's a lot of questions about scholarships and whether scholarships or grants can be directed towards one group. And I think that certainly is an area that needs to be assessed and needs to be looked at, what the specific language is of those scholarships and of those grants. So again, having that benefit to one protected class over another is certainly going to raise a bit of a red flag there. But it really is going to come down to what the language is and what it's saying, because unfortunately with some of these things there is some gray area in how it's interpreted and what the outcome is. And if you haven't hit that enforcement button, now's your time. All right, I'm just going to move ahead to the question slide, which is our last. This somehow ended up in the wrong spot. This is just a summary of what we've been talking about, and my apologies for totally forgetting about this last slide here. As you know, quotas are not permitted. We've been talking about this the whole time. There's some recent cases as well that go into this and again talk about how you really can't have target numbers for any protected class. But yeah, quotas standing alone are not permitted in the workplace to balance a workforce. Title VII applies equally to all workers. There's some thought, and I'll kind of leave you with this thinking, is that is there a way to address these issues of diversity in the workplace using different types of considerations? So thinking about it from a socioeconomic standpoint rather than one that's specifically protected by Title VII or other discrimination laws. So it's an interesting thought of ways to think about diversity moving forward, and I think that is certainly to be determined what that looks like as we continue to progress through.
And again, if we, I know we're sort of short on time here, but we will, Stephanie or I will respond to all of the written questions that have come in quickly, but maybe not right now, in writing in the email.
Yes, and hopefully you have our contact information as well, and please feel free to reach out as well.
Absolutely. Thank you.
Thank you very much.